In today's video, we're tackling a critical question facing every American. Is it actually possible to lose your U.S. citizenship? From voluntary renunciation to government-led denaturalization, we'll break down the legal pathways that could strip your status. Welcome to Travel Talk, where we unpack the facts behind borders, citizenship, and the laws that shape lives. This is essential information. So, let's find out. Subscribe, like, share, and comment. It costs you nothing, but it means the world to us. Today's topic, something most people, citizens and immigrants alike, rarely think about, but absolutely should. Many Americans believe that once you become a U.S. citizen, your status is forever locked in, permanent, untouchable. You've got the passport, the voting rights, and all the legal protections that come with them. Game over. Right? Wrong. The truth is, citizenship in the United States, whether you were born here or naturalized, is powerful, but it's not bulletproof. There are legal mechanisms, active government processes, and real-world cases happening right now that prove your U.S. citizenship can be taken away. In this video, we're going to unpack the complex legal framework, share some jaw-dropping real-life examples, and walk you through the quiet but very real government system responsible for something called denaturalization. So before you assume your U.S. passport guarantees lifelong protection, stick with us until the end. Two types of U.S. citizens, two different levels of risk. First, let's start with the basics. Who's a U.S. citizen? There are two main categories. Citizens by birth, people born on U.S. soil, including territories like Puerto Rico, Guam, and the U.S. Virgin Islands, or born abroad to at least one American parent. Naturalized citizens, people who weren't born Americans but went through the immigration and naturalization process to earn citizenship. Both groups enjoy full rights under the Constitution. They can vote, hold a U.S. passport, and receive federal benefits. But here's the critical distinction. When it comes to taking citizenship away, the government views these two groups very differently. Natural-born citizens are almost always protected under the 14th Amendment, unless their citizenship was obtained through fraud. Naturalized citizens, on the other hand, their status is the result of a legal process, meaning it can be legally reversed if that process was compromised. The most common way people lose U.S. citizenship: voluntary renunciation. Let's begin with the easiest to understand scenario: voluntarily giving up your citizenship. This is called renunciation. It's a formal process. You can't just say it on Twitter or write it in a letter. Here's how it actually works. You must appear in person at a U.S. embassy or consulate located in a foreign country. You'll sign an official oath of renunciation, acknowledging that you fully understand the consequences. There's also a hefty fee, over $2,000 as of 2025. And perhaps most importantly, it's permanent. Once you renounce, you lose your passport. You lose your right to vote. You lose access to federal benefits like Social Security. And if you want to return to the U.S. in the future, you'll need a visa, just like any other foreign national. So, who actually does this? Thousands of Americans living overseas choose to renounce their citizenship each year. Some do it for tax reasons, especially because the U.S. is one of the few countries that taxes based on citizenship, not just residency. Others renounce for political, personal, or lifestyle reasons, often because they've fully committed to life in another country. But once it's done, there's no going back. Involuntary loss of citizenship. Denaturalization. Now, let's get to the part that shocks most people. What about those who never wanted to give up their citizenship? Can the U.S. government forcibly strip it away? The answer, yes, absolutely. It's called naturalization. And while it's rare compared to Voluntary renunciation, it's happening. More often than you think. Each year, dozens and sometimes hundreds of cases are opened by the Department of Justice. Denaturalization occurs when the government determines that someone never should have been granted U.S. citizenship in the first place. The most common reason, fraud or misrepresentation during the naturalization process. This could mean failing to disclose a criminal history using a false identity, hiding military or political affiliations, concealing involvement in human rights abuses. And here's the key point. There's no statute of limitations on this. It doesn't matter if you became a citizen 5 years ago or 25 years ago. If the government uncovers fraud later, they can move to revoke your citizenship. 40 real-world cases when citizenship gets revoked. Let's talk specifics. Subscribe, like, share, and comment. It costs you nothing, but it means the world to us. This isn't theoretical. These cases are on record, playing out in federal courts. Example 1. A Bosnian man living quietly in the U.S. had his citizenship stripped after it was revealed that he participated in war crimes during the Yugoslav Civil War, something he intentionally failed to disclose when applying for immigration and naturalization. Example 2. A former Nazi concentration camp guard who had lived in the U.S. for decades lost his citizenship and was deported after his past was uncovered. These aren't isolated incidents. They're part of a documented legal trend that stretches back decades. Associations that can also lead to revocation fraud isn't the only trigger. Here's another pathway to denaturalization: joining organizations hostile to the United States. If within 5 years of becoming a citizen, you join a group that advocates for the violent overthrow of the U.S. government, serve in a foreign military hostile to the United States, or hold a significant position in a foreign government, especially without first notifying or getting permission from the U.S., these actions can prompt the government to re-examine your naturalization file. Even if you never engaged in violence yourself, your association alone can raise red flags. The government's legal position that your membership or allegiance to such organizations proves your original application for citizenship was made under false pretenses. Dual citizenship. What's allowed and what isn't? At this point, many people ask, what about dual citizenship? Isn't that allowed? Great question. The short answer: yes. Under many circumstances, the U.S. does allow dual nationality. You can hold two passports, say one from the U.S. and one from Canada, Mexico, or the UK, without automatically putting your citizenship at risk. But, and this is a big but, what matters most is your intent. If you obtain foreign citizenship with the specific goal of relinquishing your U.S. citizenship, or if you swear exclusive loyalty to another government, you could be at risk. For example, did you serve in a foreign government's high-ranking position? Did you take an oath that explicitly rejects allegiance to the U.S.? Did you engage in political activity that undermines U.S. sovereignty? These aren't just philosophical questions. They're legal criteria that the government can and does use in court. The most extreme cases: treason and rebellion. Now, let's talk about the most dramatic and thankfully least common scenario: treason or rebellion. If you commit treason against the United States, engage in an armed rebellion, or act as an agent of an enemy government, especially during wartime, you could face citizenship revocation in addition to criminal prosecution. These cases are exceedingly rare, but the laws are on the books and have been used in U.S. history. Loss of citizenship in these cases isn't just symbolic. It's a full legal process that follows conviction in federal court with appeals and intense judicial review. Subscribe, like, share, and comment. It costs you nothing, but it means the world to us. The government machinery behind denaturalization. How it works today. Now here's Something most Americans definitely don't know. The Department of Justice, DOJ, maintains an entire section within its civil division dedicated to denaturalization cases. They actively work alongside Homeland Security, DHS, and Immigration and Customs Enforcement, IC, to track and investigate cases. And, thanks to modern technology, they're now using biometric databases, advanced case management tools, machine learning algorithms, and even historical immigration record audits. This means old cases, even from decades ago, can be reopened and re-examined. If inconsistencies, criminal ties, or fraud are detected, investigations are launched, sometimes years after someone thought their immigration story was settled. Once the DOJ decides to proceed, a formal case is filed in federal court. The individual facing denaturalization has the right to hire an attorney present evidence contest the government's claims. Denaturalization is not automatic. It must be proven. But when it is, the consequences are sweeping. Your citizenship is revoked. You lose your passport. You lose your right to vote. You become a removable alien subject to deportation proceedings. And no, you don't just go back to holding a green card. You're classified as deportable. What about people born in the US? By now you're probably wondering, if I was born in the US, can this still happen to me? The good news for natural-born citizens: in almost all cases, your citizenship is constitutionally protected by the 14th Amendment. However, there is a small, rare exception. If your original birth record was obtained fraudulently, for example, fake hospital documentation, false claims of parentage, or organized birth tourism scams. In those extreme cases, the government can challenge your citizenship status. It's rare. It's incredibly difficult for the government to prove, but it has happened, especially in cases involving organized immigration fraud rings. The common thread: intent and deception. So what ties all these cases together? Intent, misrepresentation, fraud, or voluntary relinquishment. The government can't just take away your citizenship on a whim. There must be clear and provable evidence that you willingly gave it up or obtained it through fraud, deception, or illegal means. The burden of proof falls on the government, and that bar is high. But when the government clears that bar, the result is final and irreversible. The bottom line: stay informed, stay protected. Here's the ultimate takeaway: U.S. citizenship is one of the most powerful legal statuses you can hold. It comes with rights, protections, and privileges that most of the world dreams of. But it also comes with responsibilities and, yes, vulnerabilities. If you're a citizen, whether naturalized or born here, know your rights, but also know the law. Because when it comes to citizenship, what you don't know can cost you everything. This is Travel Talk, bringing you global insights and deep dives into the policies that shape our lives. Don't forget to subscribe, hit the like button, and leave a comment below with your thoughts, questions, or experiences with U.S. immigration. Thanks for watching.